This is a presentation of the King County Auditor's Office report on our audit of the civil asset forfeiture process at the King County Sheriff's Office, where we found that increased transparency would improve accountability. First off, I want to give a brief refresher on what civil asset forfeiture is. For example, if a police officer reasonably believes that a person used the proceeds from illegal drug crimes to purchase some property, at least in part, then state law allows the officer to seize that property as forfeit. The types of property that can be seized include both real property and tangible personal property, which means cash, cars, houses, jewelry, electronics, and other items of value. This is a civil proceeding against the property itself, not a criminal proceeding against the person. So that means that no arrests or criminal charges are necessary to seize somebody's property in this way. The person can challenge the seizure by claiming that they own the property or at least have the right to legally possess it. But unless that challenge is successful, the property is considered forfeit. Under state law, the seizing law enforcement agency is able to keep or auction off the forfeited property. Not all of the proceeds go to the sheriff's office, 10% goes to the state, and 45% goes to any contract city if the seizure occurred in their jurisdiction. The sheriff's office keeps the remainder and must use it to fund its own enforcement activities. Civil asset forfeiture is used by many law enforcement agencies around the state and around the country, but practices can differ from agency to agency. A few points to note as we focus on the King County Sheriff's Office in particular. First, the sheriff has a policy that civil asset forfeiture is only used for high-level felony investigations, such as trafficking and conspiracy cases, not for misdemeanor possession cases. This means that in King County, it is almost always a detective seizing property, not a patrol officer. Next, there is a dedicated unit at the sheriff's office that oversees the entire forfeiture process. There's an attorney who reviews all of these seizures and can provide advice to the detectives about what is allowed under law and policy. In addition, the King County Asset Forfeiture Unit conducts trainings for other law enforcement agencies in Washington about best practices in this area. Finally, we did not find any reports that sheriff's deputies were seizing property outside of the documented forfeiture process. We asked both the Ombuds and the Office of Law Enforcement Oversight if there had been any complaints made about unauthorized seizures by King County officers, but we did not find any. Instead, our audit focused on the process as authorized by state law. Our key findings that I'll discuss today are that the sheriff's office uses a paper-centric record-keeping system that limits transparency and program oversight, and that the language used on the notice form alerting people that their property has been seized needs to be clearer and translated into other languages. I'll start by walking through the record-keeping finding in the order of the forfeiture process, from the initial seizure to challenges to the revenue ultimately collected. The sheriff's office keeps its official records of asset forfeitures by collecting any paper seizure notice forms, court orders, and printouts of emails in physical case folders. Sometimes these case files can have hundreds of pieces of paper that must be reviewed to learn facts about the case, such as what was seized and whether it was returned or forfeited. There's also an electronic spreadsheet that has seizure information, but the sheriff's office stressed that this log is not the official record and isn't always updated. We found in our review that it did not provide complete or reliable information on case specifics. This creates an issue for transparency, since it means there's no feasible way to look across multiple cases without first reading through all of the pieces of paper in the hundreds of case folders. For instance, it makes it difficult to state with any certainty exactly how much has been seized in total, what types of property were seized, and how frequently property was returned or forfeited. Furthermore, we found inconsistencies between the electronic logs kept by the Asset Forfeiture Unit, who oversees the process, and the logs kept by the Budget and Accounting Unit, who makes the deposits and withdrawals from the bank accounts that stored seized assets. For instance, We found that there were around 275 forfeiture cases between 2017 and 2023, but cases didn't always appear in both logs. This is mostly because the asset forfeiture unit did not begin their electronic log until partway through 2017, so it's missing several cases from the first part of that year. However, we also found cases in other years that would appear in one log but not in the other. In general, both logs show the same overall trend, which is that the number of forfeiture cases has been declining since 2017, down to around 20 cases a year in 2023. The Sheriff's Office states this decline is mostly due to fewer cases involving illegal marijuana grow operations and a shift to more cases involving fentanyl. There's a similar story when it comes to the amount of cash seized. Overall, we estimate that there was around $9.4 million seized between 2017 and 2023, with the majority of that seized in a few big cases in 2017. However, there are cash amounts that only appear in either the asset forfeiture unit log or in the budget and accounting log, and based on the years and case numbers, it doesn't appear as if these amounts offset each other. So it's possible the actual amount seized is anywhere from $9 million to $9.8 million. Looking at cash seizures in closed cases, from our review of both logs, we estimate that around 40% of the cash that was seized was returned to the property owner, shown in blue on this chart, while the other 60% was deemed forfeit, shown in orange. There is still around $3 million in cash seized in cases from 2017 to 2023 that is still pending resolution. Similar to the status of cash seizures, it's difficult to tell the status of other types of seized property without first reading through every paper case file. For example, we estimate that there were around 120 cars seized during the same 7-year time period. Based on our review of the logs, we found that 43 were returned and 26 were forfeited, while 51 cars do not have a status in the electronic logs. This could mean that those cases are still pending, or that the logs simply haven't been updated with how that case was resolved. Similarly, we estimate that there were 41 houses seized, but when we look at the logs, we found that there was only one case that noted how it was resolved. It's unclear from the logs whether the remaining 40 houses are still pending or whether those cases have been resolved. Based on these findings, we recommend that the Sheriff's Office ensure that its electronic logs are accurate and up to date so that it's possible to determine information across multiple cases. We also recommend that the two units reconcile their logs to ensure that both have accurate and up-to-date information. Next, I'll discuss the one recommendation the Sheriff's Office did not concur with. As I mentioned earlier, criminal charges are not necessary for a civil asset forfeiture, but there are often associated criminal cases. These criminal cases can delay the resolution of the civil forfeiture case, sometimes for years. However, the Sheriff's Office does not track which forfeiture cases have an associated criminal case. During the audit, the Asset Forfeiture Unit researched this question and found that there was a referral to prosecutors and criminal charges filed for around half of the forfeiture cases, shown in orange on this chart. The blue wedge shows another 20% where there was a referral to prosecutors, but ultimately no charges were filed. For the remaining 30% of cases, there were no referrals to prosecutors. However, their research did not determine how frequently criminal charges resulted in a conviction. We recommend that the Sheriff's Office keep track of the associated criminal cases and their outcomes. The Sheriff's Office did not concur with this recommendation, stating that the burden of tracking this information would outweigh the benefit, since there is no automated way to look up criminal case information. This would mean that each of the 20 forfeiture cases per year would need to be looked up one at a time. The Sheriff's Office also does not track how often seizures are challenged by property owners. When we reviewed a sample of paper records, we found that out of 11 cases that did not have a claim listed in the electronic log, 7, or around 2/3 of these, did in fact have a claim reported in the paper files. We reviewed a very small sample, but it might indicate that a majority of cases could have been challenged. Similarly, the electronic log does not track how often challenges are successful, how often they fail, or what negotiated settlement was reached. Finally, the type of resolution is also not tracked. For example, claimants can go before a hearing examiner selected by the sheriff, or go to trial before a superior or district court judge, or they can negotiate a settlement with the asset forfeiture unit. None of the people we interviewed could remember the last time a claim was decided by either a hearing examiner or a judge, and it sounds like almost every case was settled between the parties before the hearing or the trial. We recommend that the sheriff consider using the independent hearing examiner's office to oversee claim hearings in order to ensure that there's no apparent conflict of interest in those proceedings. Until the case is closed, any seized cash is kept in a holding account, while the sheriff's office reconciled deposits and withdrawals made to monthly bank statements for this account. Prior to the audit, it was not able to reconcile the bank account balance with the amount of money expected to be in the account. This is because some withdrawals of money for open cases were only recorded on paper, not in its centralized electronic log. This meant that there was no accurate running total of how much money the sheriff's office expected to be held in the bank account to reconcile against. When we compared the electronic log of seizure deposits and withdrawals to the bank balance, it therefore appeared that the bank account was short by the amount of withdrawals only recorded on paper, which was around $1.5 million. Once we flagged this issue, the Budget and Accounting Unit conducted a manual review of the paper files for all open cases to try and identify these withdrawals. After the review, the discrepancy turned out to be less than $250. This shows both that no large discrepancy existed and also that a discrepancy could go undetected. We recommend that the sheriff's office continue to record all withdrawals in its electronic log and also reconcile the log to the bank balance monthly. Once cases are closed and seized assets are declared forfeit, the proceeds can be transferred to the agency as revenue. Between 2018 and 2023, the sheriff's office received $2.4 million in forfeiture revenue, shown here in blue, while $1.8 million went to its city contract partners, shown in gray, and another $500,000 went to the state. State law constrains what forfeiture revenue can be spent on. The sheriff's office mostly spent this revenue on overtime, shown in yellow, an accounting position, shown in orange, a lease for storing seized vehicles, shown in blue, as well as on legal advice, supplies, and trainings. Our second set of findings relate to the seizure notice form. When it seizes property, the sheriff's office issues all potentially interested parties with a standardized notice form that lists the property and also explains how to challenge the seizure. However, so far this form has only ever been available in English. Based on the demographic makeup of people with an identified race or ethnicity involved in civil asset forfeitures, we estimate that around 15% might have limited proficiency with English. The Sheriff's Office updated its policies in September of 2024 to increase language access to its materials. The seizure notice form is on its list of vital documents to translate into the 7 most commonly used languages in King County, and it's scheduled to be translated in the first quarter of 2025. Even for fluent English speakers, the form might present some challenges. About 2/3 of the way down the notice, there's a paragraph that instructs people on their right to challenge the seizure of their property. The readability of this paragraph is rated as difficult and as requiring a 12th grade reading level to parse. In general, a best practice is to aim for language at an 8th grade reading level, especially on documents that notify the general public of their rights. In addition, this notice says that after submitting their claim, a hearing will be scheduled for the person to prove their claim or right. This implies that the burden of proof is on the claimant, but this is the opposite of state law, which explicitly states that the burden of proof is on the law enforcement agency to prove that the property is subject to forfeiture. We recommended that the Sheriff's Office revise the notice form to use plain language and an accurate statement of the claimant's burden of proof. As always, our full report is available on our website. That concludes this presentation.